Hello and welcome to the Citywide and Contracting Labor Laws webinar for nonprofit grantees. I know some of you might be just joining us for the first time, and welcome back to everyone. My name is Beverly Popek, and I'm a Supervising Compliance Officer here at the Office of Labor Standards Enforcement. OLSE is here to help you understand your labor requirements, and we thank you for attending today. Today, we are here at session 4, the Family Friendly Workplace Ordinance, also known as the FFWO. If you haven't already, you should open up your chat box on your bottom right-hand side. This will provide you with some useful, helpful public announcements, URLs, and information that will combine a complete holistic experience to this presentation today. Materials and recording, that's one of our most frequently asked questions. You're going to be able to get a slide deck that you see here, as well as recording of this webinar on our website tomorrow. This is the URL to our website, and you'll be able to find it there. You can ask questions and get answers through the questions and answers box during the actual presentation. We have staff who will be answering questions. Now, if your question is not answered in that questions and answers box, it may be selected to be answered live during the live session. And if it's not answered during the live session, and of course during the webinar, we will email the answer to the email address that you used for the registration of this webinar. If you'd like us to contact you, give you the information elsewhere at another email address, put that into your question. Now, some of the questions may require more information, so you may be asked to contact us. So here we are. We are at session 4, the Family Friendly Workplace Ordinance. I'm your host and presenter for this particular session. Jade San Diego is in the question and answer box, and Joyce Soro is in the chat box. So let's get started on the Family Friendly Workplace Ordinance. Today's presentation, we're going to go through employee rights, who's a covered employer, and the requirements, specifically about noticing and poster requirements. The family-friendly workplace ordinance process is huge. There's a lot of details, so we're going to spend a lot of time there. And we're going to conclude this particular presentation with best practices and, of course, the resources we have available to you at the Office of Labor Standards Enforcement. This slide shows a history of the family-friendly workplace ordinance. The family-friendly ordinance started in 2013. But there was a change that altered the family-friendly. There was an amendment in August of 2022, and essentially the amendment altered the ordinance from giving employees the right to request an arrangement to the right to an arrangement, unless if an employer is able to demonstrate an undue hardship. Now, all of this is going to be unpacked later in this presentation, and I'm probably going to repeat it again so you understand your requirements and what this is all about. So let's get into the employee rights. This ordinance gives covered employees the right to a flexible or predictable working arrangement to assist for caregiving responsibilities for the following. And this is and or. It can be one or a combination of. So number one, a child or children from whom the employee has assumed parental responsibility. It also could be number two, a person or persons with serious health condition in a family relationship. And family relationship, we'll talk about that in a minute, with the caregiver. And or number three, a person who is age 65 or older in a family relationship with the caregiver. So a family relationship, it is the relationship in which the caregiver, your employee, is related by blood, legal custody, marriage, or domestic partnerships as defined in the San Francisco Administrative Code, Chapter 62, or the California Family Code, Section 297. So it may be amended from time to time, but essentially, who are these people? a spouse, domestic partner, a child, a parent, sibling, grandchild, or grandparent. Um, and bare minimum, the folks that are defined there are who we would define in a family relationship. Now, let's take a look here at if you are a covered employer. So the first part about this is, do you have 20 or more employees worldwide? And when I say employees, you have different terms for employees, and you may have contractors. So if you have contractors, my question to you is, are they indeed employees? We use the IRS definition of employee, and if you have 20 more employees anywhere in the world working for you, they could be in other places of the world, but they're working for you. Perhaps you are indeed a covered employer. Now, the second part to being a covered employer, more than in addition to having 20 or more employees, is that you must have a business location within the geographic boundaries of the city and county of San Francisco. And the business location has a definition that it's a physical space used for business to run its operations. So let me give you an example or unpack what business location means. That could be literally a workspace that you're performing work on operations. An office is ideal, but not everyone may have this. But sometimes we have covered employers who operate in the city and county of San Francisco performing work. They have an office in the East Bay elsewhere, not in San Francisco, but they do have a storage location in San Francisco. Would the storage location be a business location? If simply you're storing equipment, items, then the answer is no, because you're not using that space to run your operations kind of like on a day-to-day basis. So once you understand if you're a covered employer, the question is, well, who are these covered employees? Who's a covered employee? It's someone, one of your employees, or someone that works at least 8 hours per week within the geographic boundaries of San Francisco. Now, it does extend to telework if the employee is assigned to the San Francisco business location. And number two, the employee needs to be or have been employed for you at least 6 months or more. So that is the definition of a covered employee. So more about this telework aspect, and this is a new aspect of the ordinance that was created in the amendment in 2022, and it expands the geographic boundaries to include teleworking. So your employee may be covered under the family friendly if they're assigned to a San Francisco business location at the time of request, and it's regardless of where they're physically working. So they may work somewhere in Denver, somewhere back east, or perhaps in the Hawaiian Islands, and physically they're working there. But if they are assigned to telework and they work for your San Francisco location, this is how we define this. Now, an employee is not covered by the family friendly if they were never assigned to the San Francisco office. So, for example, say you're a nonprofit with multiple locations. You're in San Francisco, you're attending here, awesome. But let's say your nonprofit location, sister office is up in Seattle, and they learn and hear about this. Oh, are the people in Seattle covered? No. The employee needs to be assigned to that San Francisco office through telework. So let's move on into the requirements of the family friendly. What does the family friendly workplace ordinance require you to do? So number one, once you receive a completed written request for a arrangement or a schedule, you need to review to determine if you can provide the employee with perhaps a flexible or predictable work arrangement to assist in caring for their loved ones as it's defined under the ordinance. So children, family members with a serious condition, people over 65 years in that family relationship as we spoke about. Now, If you do not agree to the request, you must engage in a good faith interactive process to determine a mutually agreeable arrangement. So folks attending here who's familiar with accommodations and that request process, this is exactly the process that we're talking about. If you're not familiar with that, you need to pay particular attention. And I must tell you that we have this recorded so you can watch this again because there's a lot of details here. Now, if you, after you're considering, you're an alternative arrangements and you're still unable to accommodate the request, you need to notify the employee in writing, explaining the undue hardship determination of why you are unable to agree to the arrangement the employee is asking you to do. And the employee has a right to request a reconsideration, provide another request for maybe information and facts and other alternative um, arrangements and schedules that maybe didn't come up during the first round of the process, and you need to engage again. And then if at that point you still have an undue hardship and you have denied that person, your employee, that particular employee has a right to file a complaint with the Office of Labor Standards Enforcement. Now, this is the Family Friendly Workplace Ordinance process chart. It is found on our webpage. You are not, we're not showing you this for you to read it, but I'm showing you this because this is super, super important. And I saw that Joyce just popped the URL so you can print and have a copy if you want to print it now and follow along or look at it. But as you could see, without looking at all these little boxes and details, this is a very detailed process that you need to go through in every step of the way. There's information and possible ways that this can go. So let's really go through this process. So the first part about this is that you need to post the official family-friendly notice or poster. And we have printable versions on our website. We have English, Spanish, Chinese, and Tagalog on our website, and you can just use it and post it. When I say post it, most people think about posting it in the break room, but if you have folks that are working in and out of the office, sometimes it's best to just email this information. If the language spoken by 5% or more of your workforce is a language not listed above, you are responsible for translating and providing it to the workforce. Now, the second item here, you must provide your employees with a request form, a family-friendly workplace ordinance request form, um, or a comparable form within a reasonable amount of time after the employee inquires about the accommodation. So do they have to say, hi, boss, I want to request a family-friendly arrangement? No. If they're asking about having a schedule because of caregiving for a child, someone that's ill, et cetera, under this, it's your responsibility to provide them a request form and go through this family-friendly process. We have a sample form on our website, so go there and take a look, and you can customize your own, and then you need to make sure that you respond on a timely basis. And of course, document and keep all the notes and information of how and when this happens. Because if there are any questions, if OLSC needs to ask questions, we will ask for this information. And definitely, you need to add a policy to your employee handbook when your handbook is updated. Some more about the request. The request must be made in writing. It's very, very customary and understandable that an employee may speak to their supervisor and make a verbal request, but they need to follow up in writing and they need to put it in writing as specific as possible. So if you do get a verbal request, you must tell your employee to immediately submit the request, the information, what they're asking for in writing. The request must be for caregiving responsibilities as defined under the family friendly. There's a lot of confusion from employers and a lot of employees of what this ordinance is all about. So I mean, they work for you. They're probably going to ask. Great that they're asking, but remember, you need to understand what the family friendly is and isn't. So this is about caregiving responsibilities your employee has. Now, the request must explain how the request is related to caregiving. If it doesn't have that, you should ask for that information and you must ask them to explain it in writing. You are asking, for example, to start work 2 hours later than what you're normally scheduled, and you say this and that, but I'm not clear. How is this request related to caregiving? Really unpack and have them spell that out. The request must be specific to propose start dates and end dates, modified hours, days, work location, and what that is. Okay, so please help your employee provide that information so that when you receive a completed request, that you understand that this request is for caregiving and you understand that the person that your employee is providing caregiving is within the definition of what's in the family friendly, and you have information of all the specificities of when, where, how, and what they're asking for. That's when you can really accept a request and arrangement to really review it. So ask for that information and be very, very timely. You cannot delay. Now, request from the employee. You can't control this, but the request date should be at least 21 calendar days prior to the requested start date for all of this. Because you, as an employer, have 21 calendar days to issue determination. Now, this is ideal. This is what we have. That's what we would like. But sometimes people are in a situation where this is not possible. Maybe someone has passed, like a grandma has passed, and the grandma was taking care of the little ones. And what are they going to do? They need something immediate and as soon as possible. So please make your best efforts to make a timely decision. But the law affords you 21 days to issue a determination and work with your employee about this. So this is an overview of the review process. Starting on the left-hand side, once you receive a completed written request, you have 21 days to respond to the employee's request. You do have the right to request verification within reason. More information about that as well as online. And then the 21-day deadline may be extended if there is an agreement with the employee confirmed in writing. Let's talk about verification and what you can and should not ask for. So, an employee's attestation of caregiving duties may be sufficient, but you can request verification within limits. So you may ask the employee to provide a note confirming the obligation. So for example, maybe there's a standing medical appointment Tuesdays at 3 p.m. Okay, so maybe that's the request. Every Tuesday at 3 p.m., this person would like to have 2 or 3 hours off to take someone to that medical appointment. Now, you cannot ask for confirmation about the reason. Why are you going to this medical appointment? What is this for? And things like that. You cannot ask that, oh, can your other family members do this? The person, your employee, is asking because they are saying that they are the caregiver. Now, you can't ask these things if there's no basis to believe the employee's attestation is invalid. So let's talk about one of the easiest things to do. If you're able to grant the request, then you should approve the agreement and you should put it in writing, the approval, and this must be completed within 21 days of when you receive the employee's request. And 21 days, it's calendar days. So just FYI here. and you need to count, you need to keep track, you need to be organized. If you don't have someone assigned to do this in your organization, the best people are people that have attention to detail and who will be timely and can really engage your employees to figure this out. So if you cannot accommodate the requested arrangement, you have to engage in this interactive process. And so what that is that you need to meet with the employee so that you can discuss any alternative arrangements that can satisfy your um, operational need as well as, of course, the employee's caregiving need. But backing up from all of this, you must understand what is the caregiving need? What are the specifics of the caregiving need? Is it Tuesdays at 3 o'clock, 2 hours off, or are you flexing it off? Can you make that time off? Is there any other time that you can do this? Now, for some of these medical standing appointments, depending on your experience with medical standing appointments, sometimes these appointments cannot be changed, and sometimes the appointment kind of rotates, so it's not possible sometimes with employee that may know everything. So you need to ask questions, but understand, what the caregiving need is so that you can figure out what is the schedule this person asking for, what is their need, and perhaps is there an alternative arrangement that effectively meets your employees' caregiving responsibilities that they haven't thought of. So your employee is probably going to propose what works best for them, their preferred. What is preferred may not be what may work out with your operations, and there may be an arrangement, another arrangement that your employee has not thought of that could work for them to meet their caregiving need and also work for you as meeting your staffing requirements and scheduling. So this interactive process is really, really important. You have to attempt this in good faith to determine this flexible or predictable working arrangement that's acceptable to them, your employee, and you. It has to be timely. Please keep track of things and exchange essential information without delay and obstruction of the process. You should analyze the functions and purpose of that employee's position in relation to the operations of what you're doing in the organization. And you should consider the requested arrangement. But again, as I said before, you may be able to just approve an alternative arrangement that meets your employee's caregiving need as well as maybe your operational need. That is allowed. That would be in compliance. So just keep that in mind. Now, if you do provide an alternative arrangement that meets the caregiving need of your employee, but the employee says, no, thank you, I'm not going to take it, then you have met the requirement of this ordinance. You are in compliance. The process is done. Now, the employee may not understand that. I'll be very, very honest with you. A lot of the calls we get, the employee doesn't understand what this ordinance is and what this isn't. So you should tell them or you should have them call us, OLSC, to have a smoother process. So again, if you want to provide an alternative arrangement that meets that caregiving need and check it really close, make grids, charts, and have a second pair of eyes do this, and the employee declines, you're in compliance and there's nothing to do. Now, what if no agreement is met, and you can't figure out an alternative way and it happens, right? If you seek to deny the request, the only thing that you can use to deny the request is that you must prove undue hardship, demonstrating that the request would cause a significant expense or operational difficulty. Now, you're not required to alter or impede your operations that would cause significant expense or operational difficulty. So if the request, the arrangement, the schedule is doing that, you need to document and show that, and that is what you would use as part of how you would prove undue hardship, meaning you can't You can't agree to the arrangement that the employee is asking for. So let's unpack this undue hardship reason for denial. Um, and remember, this is the only reason you can deny. So number one, the money sign here, if it's causing a significant expense or operational difficulty when considered in relation to your size, finance, resources, nature, or structure of your business, then that may be the reason for your denial. You have to document it. You have to show the calculations. That's what we would ask for. That's what we would want to see. If you give the reason of undue hardship to the employee, which you will have to do in writing, you're going to have to explain it, but you may not have to, and you don't have to put down all of the calculations, charts, and stuff. You would perhaps show, oh, let's see if we ever have to ask for this information. Now, the denial must be in consideration of the most current arrangement the employee has requested, whether it be the original request made or the alternative arrangement identified in the interactive process. So if you've never gone through this before, I'll tell you this. Maybe the employee asks for one arrangement, but during the process, it changes. You may ask the employee, is there any other way you can do this? They go back to people, and then they're able to say, yeah, maybe we could do this, but then you're like, oh no, maybe not. You need to follow, you need to have that attention to detail and understand what is the most current arrangement that everyone is talking about and looking for. um, Now, if you're going to assert undue hardship, this is something that you need to understand that the reasons of undue hardship is the only reason that you can deny it. And then if you can only, if it's, there's only part of the request that you can't do and it's because of undue hardship, then you can issue a denial. But if there's another part in which you can accept and you can agree to, then you must accommodate. So, in other words, you must comply with the provisions of the request that, you cannot demonstrate undue hardship. So these things are kind of complicated. You have to think about that. If you've never been through it, it may not make sense, but each situation is unique and it's subject to individualized analysis. And so you should consider circumstances in determining whether you can or cannot and whether it really is undue hardship. So taking notes, attention to detail, understanding, brainstorming all alternative arrangements that may meet that employee's caregiving need. And in turn, you're trying to figure out what's going to work best and how is it going to work in your operations without that undue hardship. And you may have to, of course, bring in supervisors and managers to figure that out. Um, if you're going to deny, you need to put it in writing. And this is at bare minimum what you need to have. Number one, the explanation of the basis for the denial and undue hardship. And then two, if this is the first time that the request and the first time you're denying, the employee has the right to request a reconsideration to you, and they should be requesting perhaps something else or providing other information that perhaps you didn't understand. That's very clear in your denial. That happens, and they have a right to reconsideration. If by chance that you've been through the reconsideration process, which is exactly the same process that I just went through, but a second time around, and you come to denying again for undue hardship, because that's the only reason, you have to notify the employee at the final denial that, they can file a complaint with the Office of Labor Standards Enforcement. So here is the request for reconsideration process. Oops. And the worker has a right to request a reconsideration within 30 days after you deny them. And these are calendar days. And you, the employer, must meet with the employee within 21 days to discuss and reconsider the request. And number three, you must issue a final decision in writing within 14 days of that meeting. A meeting can be virtual, it can be in person, it can be over the phone. Emails and correspondence that way does not is not sufficient for the definition of a meeting. The final denial, again, if you're going to provide that final denial, if that's your situation, you got to put it in writing within 14 days of the meeting and provide that information that the employee can file a complaint to the Office of Labor Standards Enforcement. So an employee can file a complaint with us if they received a response from you and there was a denial, or if the time frame has elapsed. So you're here in 21 days, 14 days, there's a lot of days, calendar days, mind you. Um, if you are behind, your employee has the right to complain, and we will call you to ask you to move along in the process. So please keep track of the days and times. Now, here's information about enforcement penalties and appeals procedures. Our rules and regulations that's found on the Family Friendly Workplace Ordinance webpage has all information about these sorts of procedures and things like that. And let's round up here with our best practices. So when you have this interactive process, you must attempt it in good faith. Have an open mind and understand, number one, what is the caregiving need? Specifically, do you have all the information about that, like the details, like where is the drop off or pickup at school versus where is that located with the office location versus where is it located where that employee works. This information is super important when figuring out, well, can this person work 8 hours in a day? How can they add up 8 hours in a day and where that work location will be? So you need that sort of information and come in good faith to figure out an arrangement that may work with the caregiving need and possibly for yourself if you just cannot agree to the arrangement as requested. You know, this process needs to be timely and definitely orally or in writing. I think the best practice is to meet and just follow up in writing. Memorialize everything in writing and keep careful notes about reasons and information. It's going to be helpful. And also, you need to do an analysis if you're going to deny calculations with why you say it's an undue hardship and save all your documents involved in this process for at least 3 years after the request is received. And remember, every situation is unique and subject to individualized analysis. Here is some information of where you can find our webpage, and we have our process chart, which is super important, posters, rules and regs, as well as of course, we have video on demand for this. And this is our general contact information, our phone number and our email address, and again, our website. Um, so yeah, now we're here at our questions and answers session, and I know that Jade's been working in that box. Hey Jade, do we have some questions for this session?
Hi, Beverly. Yes, thank you. So we did receive some questions, and I tried to answer them as best as I could in the Q&A box. But if I missed one or did not address it, again, I think Beverly mentioned we will respond via email to the email address that you used to register. Now, a lot of the questions were similar, so I tried to combine them. But the first question we have, the FFWO is very overwhelming. What is a common misconception or misunderstanding of the FFWO? What should we keep in mind to avoid these issues?
So yeah, there's a lot there. It can be very overwhelming. And even if you go it through once and twice, I think there's always things to learn. Um, our our best practice and our advice to you is you should print out the Family Friendly Workplace Ordinance process chart. And every step of that process and process chart should be followed for every single employee. You should print out the rules and regulations so that you understand definitions of who is a primary caregiver. Maybe an employee asks for an arrangement, and when you look at it and you look at the definition, it doesn't meet the definition, so therefore the employee doesn't have a right to make or ask for an arrangement. There are a lot of details. It's a highly intensive, involved process. Whoever's doing this for your organization needs to have attention to detail as well as be able to look at the big picture of is there an arrangement that can meet the caregiving need and our need, the nonprofit? You need to have that sort of attitude and temperament in your staff that's processing it, and just going, you know, very deliberately in understanding your obligations of where you are in the process of how much time do you have. And remember, write down its calendar days. So 21 or 14, you got to meet. And if you need more time, because things happen, people are on vacation, but people need to ask, people need to, life goes on. Please ask for an extension and have the employee say yes in writing. Make it very clear on the record that the employee said, yes, you can have, 5 more days because so and so is out of town or at a conference. So those are some, I guess, tips or best practices and to avoid issues.
Thank you. Next question. What if the employee asks for a schedule that doesn't work with our operations, and the employee's position and skills? Do we have to approve the schedule? So it sounds like this person believes that there is a business reason for why the schedule can't be granted, and they are asking for more information about what is a bona fide business reason for denying a request. Can you go through this again and some examples maybe of a bona fide reason to deny a request?
Right. So there's a lot there. So folks, if you ask the question, and this is not sufficient in what I'm going to say and share because of time and for whatever reason, feel free to contact our unit and please ask to make an appointment because something like this would be like, I would say ask for a 45-minute time slot because I'm
Oh,
sure there's other questions that arise. But let's try to so if someone's asking for a schedule that just doesn't work with your operations because that person's position is key for a specific time and a specific purpose, you may have a reason, an undue hardship reason why you could deny it if that's the only person. So, for example, if you have a receptionist, a person who sits at the front desk that greets and does clerical and other things, and that's the only person, and this is an in-person position that needs to be there during your hours that you're open for your clients and people you service, and there's no one else, perhaps that's an undue hardship. And that is something that you can look at as maybe an undue hardship if you have no one else to do backup. Well, maybe the person requesting could say, well, every lunchtime you have Jade fill in for me while I'm at lunch. Can't you have Jade work in the front desk more? I mean, that's something for you to consider, but it may be an undue hardship because based on the position and schedule and requirements that you need the person to work in person at that desk 5 days a week for 8 hours a day. So that could be one of the reasons. I don't know, Jade. You've looked at the question a little bit more. Do you have anything else to offer in terms of a
Um,
possibility or some advice?
yeah, no, that just, I mean, if there's only that one employee, you have to give that employee a lunch. So if there is anybody that could cover during lunch, maybe during that accommodation is needed for, that would be something to consider too. Yeah.
Yeah, that would be something to consider too. Um, but then it gets complicated because, I mean, if Jade's covering for my lunch, maybe half an hour each day or 1 hour a day or something like that. But then now I'm asking, I need 3 hours off. I cannot work because I need to take my elderly mother who has health issues to a standing medical appointment. So every Tuesday, I need this time off. Is Jade going to be available to cover for me in that front desk position? I don't know. That's a question for you. Maybe Jade has some standing, operational duties and requirements in which she's performing
Mhm.
that may be an undue hardship, or maybe it's not. So we need to eh, we need you to contact us if you need more information. And obviously, these are all hypotheticals, and if you are going through something right now, definitely contact us right away because you have 21 days or 14 days, depending where you are in the process, to figure this out.
Yeah, yeah, it is a case by case scenario for each one, so definitely
Right.
call us. The next question, does this apply does this law apply to all employers and their employees in San Francisco?
So the answer is no, you need to look at the information of who is a covered employer and the definition of covered employee. So covered employer, you need to have at least 20 or more workers anywhere in the world. And then you also need to have some sort of location in San Francisco that you operate from, not a storage location. So if that is yes and yes, then you're a covered employer. Then the next step is, do you have any covered employees? Your covered employees would be people working at least 8 hours a week. For, I would say, 99.9% of everyone today, you probably have someone working 8 hours per week, but they have to be employed at least for 6 months. So before there's another question about that, I'll say that if that's the case where someone has worked for over 6 months and they leave and they went on a leave of absence and they come back, you need to treat them as if they've been there already for 6 months and look at their arrangement and what they're proposing. So just because they go on leave, that doesn't reset the clock. That's something I think people always ask us.
Mhm, mhm. Yeah, thank you. Next question, can you tell me more about what is considered caregiving? Is a parent saying they have to take their child to school caregiving?
Right. So caregiving is super specific. So I would go back to the rules and regs where we have a definition of what caregiving is, but caregiving is defined as the reasonable and necessary ongoing of supervision or care of a child or family member, as remember what the asterisk is defined under the law, for maybe their physical and mental well-being. So to answer the question with pick up, drop off, school, that sort of thing, yes, that is caregiving. And I think that's the answer, and you'll have to unpack it. And yeah, I don't think we have any more time. It looks like we have some more questions, but folks, I would say if you didn't get your answer to your question, just give us 24 hours. We'll respond back to the email address that you used, and certainly you're always welcome to make an appointment with us. Thanks again, Jade, and thanks again, Joyce.
Thank you.
And please join us at 2 minutes to go into our paid parental leave ordinance session. I'm just going to do a quick audio check with Bernice Casey, who is our presenter. Hey, Bernice, I can see you.
Good morning, Beverly. How are you?
Great. Your audio is fantastic. Let's start in 2 minutes.
Great.